again, have the same history of colonialism. And it was in 1833 that the Judicial Committee of the Privy Council was established. Interestingly enough, it was in that same year that the Slavery Abolition Act was also passed. Historians, scholars of the view that this was done to keep control of what transpired in the colonies. They recognized, they did, that there would be disturbances, arguments among the plantocrats in these islands. And as such, they had to establish this committee called the Privy Council to adjudicate on matters of this nature. But the colonies soon became independent nations. Let me pose this question to you. Can we really say that we are really independent when a foreign tribunal makes determination of matters involving civil litigation in these countries? Clearly, the answer must be no. Let me be so bold as to state this. It was Sri Lanka, Malaysia, Singapore, some African countries like the Gambia, Hong Kong, who took the view that they must become independent nations to be completely sovereign. Indeed, it was Justice Hayatali, the Chief Justice of Trinidad and Tobago, who made statements many years ago that echo always in my mind. Most of those countries, it was stated, thought it was offensive to our sovereignty, they say, to have a foreign tribunal determine our matters as a final court of appeal. It was offensive to our sovereignty to have a foreign tribunal as our final court of appeal to determine matters involving litigants in the jurisdictions. My people of this wonderful nation of Antigua and Barbuda, I said before and I ask you again to catch the vision and live the dream. Let us forge forward. And on that day, when the vote is to be taken, I'm asking you to do the right thing and to vote for the Caribbean Court of Justice. You know, there are certain persons, you know, who have doubts in their minds about the CCJ. Those doubts, I say, are without merit and foundation. Independence. The court is totally independent. And you will hear during the deliberations and presentations the mechanisms established to ensure that the court was as insulated and free from political interference. Indeed, my dear friend, the Prime Minister from Belize was quite clear. He had to appear before the court, his country, appeared before the court many times. And even though he lost, he was satisfied that the court did its duty and did its duty properly. Interpreting the laws, giving judgments which are sound, and speaking about the quality of our judges, you will hear that the judges are selected by an independent body, the Regional Judicial and Legal Services Commission. You will hear, as we educate you on these matters, costs. Indeed, my friends, you heard Sir Gerald Watt some days ago indicate, it's an extremely expensive process to prosecute an appeal before the Privy Council. It starts at about $150,000. Not in these parts. Many persons, therefore, poor people with whom this government is concerned, were unable and are unable to assess and to have access to the court for judgment, for their rights to be declared. Not with the CCJ, you know. It's an itinerant court that travels from country to country. That the poorest man on the street, once he feels aggrieved that his rights have been offended, will have access to the court for determination. I say to you all today, the Privy Council must be made the final court of appeal in our jurisdiction. We are a Caribbean people. CCJ We are a proud people. We are Caribbean people. The CCJ is the way we have to go. Sir Dennis Byron, the president of the court, vast experience, sat in international forum all over the world. Do you know that our judgments indeed are quoted by the Privy Council? Our judges have the standard, the qualifications, the experience. You will hear during our presentation the type of scrutiny that one goes through before one is appointed a judge of the CCJ. As a Caribbean man, I'm pleased to be associated with this move. Antigua and Barbuda, my friends, have always been in the vanguard of integration in these parts. So on that day, when it is appointed, I'm asking all Antiguans and Barbudans to gird your loins, join the battle. Don't be afraid. There's nothing to fear except fear itself. People are resistant to change, but this is a change for the better. I want to tell you that this government, Gaston administration, we have the political will to bring this to reality. We want to continue the vision of those three great West Indian pioneers, the forefathers, Byrd, Barrow, and Burnham. I once heard the Prime Minister from Barbados said very jokingly, it was Byrd, Barrow, and Burnham that started Carifta. You know, Guyana, Barbados are already subscribing to the CCJ. Now, it is the turn of Antigua and Barbuda to do so. I ask that after this education program started by us, which, as I said, is designed to inform, to enlighten, and to educate, that on that day you do the right thing and vote for the CCJ. Having said those few remarks, I now call upon Mr. Clarence Henry, who's done quite a good job in organizing this thing. We will have a presentation, a short presentation, which we'll ask you all to listen to, and it's coming from CARICOM, the Secretary General, Ambassador Erwin LaRock. Let's have that video, please. And whilst we wait, we welcome, of course, the leader of the opposition in Parliament, Baldwin Spencer. And this was an opportune moment, I think, because both political parties are of one mind, and that is to ensure that the CCJ becomes the final appellate court for this country of Antigua and Barbuda. And I'm certain that the technicians are in place, and we are eagerly awaiting the tape, which is to be played at this particular point in time by Ambassador Erwin LaRock.
Governor General Sir Rodney Williams, Honorable Gaston Brown, Prime Minister of Antigua and Barbuda, Speaker of the House of Representatives, President of the Senate, Dr. the Honorable Baldwin Spencer, Leader of the Opposition, Right Honorable Sir Dennis Byron, President of the Caribbean Court of Justice, other members of Cabinet and Parliament, Ambassador Dr. Clarence Henry, Chairperson and Master of Ceremonies, members of the Diplomatic Corps, ladies and gentlemen. I welcome the opportunity to take part in the launch of this public education program, which seeks to inform about the Caribbean Court of Justice, the CCJ. Technology has assisted me in my determination to stand with Antigua and Barbuda as it moves towards completing its circle of independence. I wish to commend the government and opposition for this bipartisan approach to the country's accession to the CCJ, based as it is on the Memorandum of Understanding on Constitutional Reform of July 2015. This public education program, one of the activities agreed to under the MOU, is a most welcome step in advancing dialogue on this matter. Dialogue is important as it presents the opportunity for the sharing of information as well as concerns. The discourse on the pros and cons of adopting the CCJ as Antigua and Barbuda's final court of appeal, as opposed to retaining the Privy Council, is not new. The CARICOM Secretariat, prior to the establishment of the court, and even thereafter, along with a number of member states, engaged in public education to sensitize CARICOM nationals about the court. The CCJ is intended to be both an international tribunal in its original jurisdiction and the highest municipal court of member states of CARICOM. It functions as an international tribunal and therefore applies international rules when interpreting and applying provisions of the revised Treaty of Chaguaramas. As a final municipal court, it replaces the Privy Council, which serves that role in a number of our member states and will consider and determine appeals in civil and criminal matters from local courts. Antigua and Barbuda signed the agreement establishing the Caribbean Court of Justice on the 14th of February 2001. This agreement was ratified on the 17th of February 2005, subject to the reservation in respect of Article 25, which speaks to the appellate jurisdiction of the court. So Antigua and Barbuda, like all the other member states, is therefore subject to the original jurisdiction of the CCJ. In order to make the CCJ its highest municipal court, Antigua and Barbuda has to take certain steps, the most important of which is a referendum. In any comparison of the CCJ and the Privy Council, it is important to recall the intentions behind the establishment of the court. In establishing the CCJ, our heads of government took steps to ensure that it complied with the highest international standards and would be a completely independent institution. The original Judicial and Legal Services Commission, RJLSC, was instituted as an independent body to appoint the judges to serve on the court. The RJLSC comprises of representatives of regional and national law and bar associations, national, judicial, and public service commissions, representatives of civil society, and outstanding jurists. The heads of government appoint a president guided by the recommendations made to them by the RJLSC. In the more than 10 years of its existence, we have been fortunate to have two excellent presidents in Justices Michael de la Bastille and Sir Dennis Byron. The court has also been staffed by judges of the highest intellectual caliber. Further, a trust fund was set up to finance the operations of the court in perpetuity, ensuring that it would not depend on the public purse for its work. It is clear, therefore, there is no court in the world, including the Privy Council, which is as completely independent as is the CCJ. Further, the CCJ provides much more affordable access for final appeals. Access to justice is one of the most fundamental of human rights. It would be a travesty if one cannot exercise that right because of financial or traveling constraints in accessing the Privy Council in the United Kingdom. Another important consideration is the replacement of the Privy Council with a court that is homegrown, with justices that understand the socio-economic, cultural, and general dynamics of the community. Since its first appellate jurisdiction case in 2005, the CCJ has certainly affirmed the foregoing as well as other arguments supporting its existence. To date, the appellate jurisdiction of the court is accessed by Barbados, Belize, Dominica, and Guyana. I look forward to Antigua and Barbuda joining those countries. There has been a marked increase in appeal cases from those countries to the CCJ when compared with the Privy Council. In the first half of 2014, there was a 67% increase when compared with the same period in 2013. In the case of Barbados, there were 8 appeals heard by the Privy Council in the first 5 years immediately prior to its accession to the appellate jurisdiction of the CCJ. In the 5 years that followed, 12 appeals were heard from Barbados. In the case of Belize, which accepted the appellate jurisdiction of the court in 2010, there were roughly 2 appeals per year to the Privy Council. But since its first appeal to the CCJ in 2011, there have been 12 appeals by mid-2015. Although Guyana abolished all appeals to the Privy Council in 1973, appeals to the CCJ have been exponentially increasing. These statistics can be judged in the context of the fact that to file an appeal before the Privy Council is about 5 times the cost of doing so with the CCJ. In the discussion of costs and accessibility, it must be highlighted that the court has sat outside its headquarters in Trinidad and Tobago, having done so in Barbados, Belize, Guyana, and Jamaica. The CCJ is therefore providing the laudable purpose of bringing justice closer to the people of the community while also making it more affordable. It is important to note that the Privy Council functions as an appellate court in a restricted manner. Appeals to the Privy Council in civil proceedings lie at the discretion of the local court in certain specified instances. In criminal matters, the Privy Council generally will not intervene unless there is a question of constitutional interpretation or question of breach of a fundamental right or freedom. The range of precedent generated by the Privy Council as the highest court for some CARICOM jurisdictions is therefore confined to narrow categories, particularly capital punishment and high finance. Also important is the fact that as an integration grouping, having two courts operating in the same jurisdiction would lead to confusion and inconsistencies in interpretation of laws. This would, in turn, affect development of a CARICOM jurisprudence. It is clear now that the Caribbean Court of Justice is here to stay. In fact, its very existence for more than 10 years establishes its permanency, workability, and has alleviated many of the fears and arguments supporting the retention of the Privy Council. The role of a regional court cannot be overstated in the context of regionalism and the promotion of a regional identity. The CCJ has proven beyond a shadow of a doubt through its erudite judgments, the caliber of its judges, and its accessibility, that it is a court of the highest international standard and is therefore making a significant contribution to our region completing its sovereignty. Thank you.
Please make a round of applause for Ambassador Larocque for that address. You would note, he repeats, the court will be accessible to all individuals who have a legitimate claim. The costs, as indicated in that presentation, for the Privy Council is 5 times what it will cost here in the Caribbean region. Our Caribbean judges are more familiar with our lifestyles and our patterns. We must develop our own jurisprudence. It's essential that that be the position. It took many centuries to develop the English judicial system. It's about time that we as the people together, work together in unison to develop our Caribbean Court of Justice. The next item in the program will be a dance by the National Dance Theatre of Antigua and Barbuda. These people have demonstrated their abilities, the cultural heritage, and it also shows the extent to which we must make a decision in favor of the Caribbean Court of Justice, the National Dance Theatre. Thank you very kindly. A very good presentation by National Dance Theatre. Our next presenter, the High Court Judge, Justice Fleeta Lance, who has been here in Antigua for many years, and she's now representing our own Chief Justice in this matter. It gives me great pleasure, therefore, to present to you this morning Justice Fleeta Lance, High Court Judge in Antigua and Barbuda. Good morning.
Thank you, Mr. Master of Ceremonies, Your Excellency, Governor General, Sir Rodney Williams, the Honorable Prime Minister, Sir Gaston Brown, the President of the Caribbean Court of Justice, Sir Dennis Byron, Honorable Attorney General, Mr. Stedroy Benjamin, and Mr. Master of Ceremonies, please permit me from here on to adopt the protocol so ably established by you. I have been asked to give brief remarks on behalf of the Honorable Chief Justice of the Eastern Caribbean Supreme Court, Dame Janice Mercedes Pereira. Dame Janice would wish to thank the National Consultative Committee for inviting her to these proceedings and regrets that she's unable to attend because of pressing work commitments. Mr. Master of Ceremonies, the Honorable Chief Justice applauds and commends the efforts of the National Consultative Committee for spearheading the preparations for the National Public Education and Sensitization Program ahead of the national referendum. And the Eastern Caribbean Supreme Court pledges its full support to the launching of the Public Education Program and the Public Sector Consultative Program to raise awareness and support for the Caribbean Court of Justice. Dame Janice hopes that the discussions would be fruitful, particularly in relation to sensitizing, edifying, and educating the general public and stakeholders. Dame Janice believes that a program of public education is an essential plank in the decision-making process in relation to the intended move from the Privy Council, which serves as our highest court. However, in terms of putting forward a particular position on the question as to whether the OECS and any Caribbean country should do away with the Privy Council, the Honorable Chief Justice holds the view that it would not be appropriate, having regard to the fact that the Eastern Caribbean Supreme Court comprise an intermediate appellate court, to put forward any particular view as to the choice of the final appellate. This is a matter to be decided by the heads of state on behalf of their citizenry or together with their citizenry, as the case may be. Mr. Master of Ceremonies, distinguished guests, ladies and gentlemen, may the Public Education Program and the Public Sector Consultation here in Antigua and Barbuda and throughout the OECS and the wider Caribbean be a successful exercise with immense benefits to all concerned. I thank you.
Thank you very kindly, Justice Lance. To me, the next presenter is very close to my heart. It was in the early 1980s, as a very young barrister, having been called to the bar, I was told that there was a judge from St. Kitts coming to Antigua to sit on the bench. As this gentleman approached and sat on the bench, there were many of us sitting before him that day. And I looked at Sir Dennis Byron. I said, my lord, your stay in Antigua will be a beautiful one. But remember, my name is Steadroy Cutie Benjamin, known as Cutie. Always refer to me as Cutie. I was there with Sir Dennis when he started from St. Kitts. Then as he sat as the Chief Justice in the appeal courts here in the region, I appeared before him as well. As he traveled the world, the ICJ, criminal court in Africa and all over the world, Sir Dennis and I also maintained a very close relationship. And now, I'm so happy that someone from the smaller islands, I dare say, from St. Kitts and Nevis, that federation, now heads that great austere body, the Caribbean Court of Justice. It gives me greatest pleasure to welcome to the podium my dear friend, mentor, Sir Dennis Byron, President of the Caribbean Court of Justice. Sir Dennis.
Thank you very much for that warm welcome. Your Excellency, Sir Rodney Williams, Honorable Prime Minister, Sir Gaston Brown, Honorable Leader of the Opposition, Mr. Baldwin Spencer, distinguished Judge, Madam Justice Lance. As I look around and I see so many learned and distinguished people here, who I ought to personally recognize, I crave your permission to adopt the protocol rule already established. But having said so, I still want to mention two people specifically. I see in the audience Sir David Simmons. And it's really a pleasure to see him here on this occasion, because Sir David Simmons was the first chairman of the Regional Judicial and Legal Services Commission and was responsible for all of the foundational work that created and established the Caribbean Court of Justice. The other person who I must especially mention today is Sir Gerald Watt. Now, interestingly, on that first morning when I appeared before, when I sat as a judge here in Antigua, young, nervous, not certain what the future was going to be, Gerald Watt was also in court. And he has appeared before me as a trial judge, as an appeal court judge, over many years. And yesterday evening, I was really moved when I heard him state that one of his biggest dreams is to appear before the Caribbean Court of Justice before he hangs up his boots in retirement. Sir Gerald, I hope your wishes come true. I must also say that I've been invited to speak, make a few remarks on the original and appellate jurisdictions of the court. Very specified topics, but which are topics which enable wide-ranging discussions that go on for quite some time. So I have to select just a few thoughts to share with you on these issues. But before I do that, I want to just emphasize something which has been referenced earlier. It was, for me, a greatly inspiring experience when the Prime Minister indicated to me that he wished to embark upon this road. But he was not willing to do it unless there was a bipartisan approach by the political parties in this country. And he asked me to try to facilitate it. So I approached His Excellency, Sir Rodney Williams, who invited the political leaders to a conference at Government House in Antigua. And I thought I must say publicly that on the day when that conference was scheduled, there was very hostile political activity in the country because the opposition was picketing the government about an issue related to immigration. But you know, the opposition leaders left the political hustings. And as I said jokingly the other evening, Harold Lovell, who had been parading before the crowd, washed his face, put on his jacket and tie, and with the leader of the opposition, came to Government House and sat across the table from the Honorable Prime Minister and the Attorney General. And in introducing the discussions, they explained to His Excellency that they considered that the national interest of Antigua would be best suited by acceding to the final appellate jurisdiction of the Caribbean Court of Justice. And they thought that the national interest was so important that it had to take precedence over party political differences. I must say, I was inspired by the demonstration of political maturity from the leaders of this country. And I trust that as you move forward towards the referendum, that will be the hallmark of the arrangements that take place here. The second preliminary thought I want to give is everybody talks about the economic realities of our times. But who should waste money? When the Caribbean Court was originally established, the financial arrangements for the court included the establishment of a trust fund where member states invested $100 million with the expectation that the interest from that investment would fund the court in perpetuity. And when the trust fund published its financial reports after the first 9 years of operation, it had spent $47 million and a bit more, supporting the operations of the court. And it still had the $100 million in account. The interest of which continues to support the court. Now, I gathered from discussions around this country that it was not well known that Antigua and Barbuda has paid in full its contribution to the trust fund. So that accessing the final appellate jurisdiction of the court will not cost the government 1 cent more. And if I might refer to my original remark, you are already in the position where you have made an investment which you have not fully reaped the benefits of. And I know Mr. Economist, Prime Minister, doesn't like that. Now, the original jurisdiction of the court is a term used to describe the function of the court in resolving disputes that relate to the interpretation and application of the rights arising under the Treaty of Chaguaramas. The political fathers envisaged that the secret of economic development and social stability in the region lay in establishing a single market and economy for our region, which is aimed at deepening regional economic integration in order to achieve sustained development based on international competitiveness, functional cooperation, and enhanced trade relations within member states. And fostering the unrestricted movement of capital, people, and technology, so that the collective relations, the collective resources of the region could be utilized by all on a non-discriminatory basis. Now, these laudable objectives are very similar to the objectives which the European Union has, and the European Court of Justice exercises a similar jurisdiction to the Caribbean Court of Justice in that regard. Now, that treaty has been incorporated into the laws of Antigua and Barbuda, as in all other countries in CARICOM. Now, the first point I want to make about the original jurisdiction is that it is exclusive to the Caribbean Court of Justice, and it is also final to the Caribbean Court of Justice. This means that if in any case appearing before the domestic courts in CARICOM, there is an issue concerning the interpretation or application of the treaty of the court that must be referred to the Caribbean Court of Justice for adjudication. the benefit of that is to create absolute certainty on the legal provisions which are applicable. Because there's one court which decides all issues related to the treaty. And that court is the final appellate jurisdiction of the Caribbean Court of Justice. Now, the court has a track record of 10 years. But during that period, none of the countries involved in CARICOM have had any cases in their domestic courts where issues related to the Treaty of Chaguaramas has been filed. But people have filed cases before the Caribbean Court of Justice. And I think it's important just to give you a snapshot of the type of cases that have come before the court. Because people would have thought initially that when you have cases arising from a treaty, that the parties to the cases would only be the member states. But up to now, not one member state has filed any case. The cases have all been filed by commercial corporations and private citizens of the region, and also by one of the CARICOM institutions which have been established to guarantee fair competition in the region. So I don't have very much time, so I'll just mention that briefly, that we have had cases where, for example, a Trinidad exporting company, a cement exporting company from Trinidad, who was exporting cement to Guyana, felt that Guyana was in breach of its treaty rights by not imposing the agreed tariffs against cement imports from non-CARICOM countries. And the Caribbean Court of Justice ordered Guyana to pass the legislation. And it did. Corporations in Suriname selling wheat products, pastry, and that sort of stuff, who are suffering competition from companies in the Netherlands who were exporting to Suriname, came before the court and said, look, our treaty rights require our government to impose certain tariff rates against foreign imports which you have not done. And the court made an order directing Suriname to pass the necessary legislation. And Suriname did. Most recently, we have had a very interesting case called the Rhodesia case, where a beverage manufacturing company in Suriname had been exporting beverages to Guyana for sale there. But when the beverages crossed the border into Guyana, an environmental levy was placed on those beverages that was in breach of the Treaty of Chaguaramas. And they came to the Caribbean Court of Justice. And the court made an order requiring Belize to remove the restrictive taxes and to repay to the company the taxes which had been illegally collected. And Guyana did. You know, I listen very often to people saying, what are the enforcement powers of the Caribbean Court of Justice? Now, I ask you, why should a court like ours need special enforcement powers? that are out of the enforcement powers which are currently existing in our normal laws. I recall when I was younger and practicing at the bar, in the days when we were under the colonial administration of Great Britain, we were taught the court never makes a mandatory order against the crown. It only declares what is the correct thing for the state to do. And because the crown is expected to observe principles of good governance, that would be sufficient to guarantee obedience to the court rules. Why should current governments in the Caribbean region be treated with less respect than that? And as I have said, in each case, the governments against whom orders have been made in the commercial areas have, in fact, I just received a message yesterday indicating that the last payment of a fairly substantial repayment regime for the Rhodesia case was paid by the government of Guyana yesterday. Now, the most famous case we have had has been the case of Shanique Myrie from Jamaica. And you know, I like to refer to a particular aspect of that case. Because who was Shanique Myrie? A young woman, no particular educational background, no particular power base in the community, no particular money, nothing to back her up. Yet, she felt that her rights had been aggrieved, breached by a government, the government of Barbados. And she brought her case to the CCJ. Poor, ordinary CARICOM citizen come before the court and get a judgment against a government. And the government paid her the compensation the court ordered. You know, I must tell you though, the disappointment I have is this. I read the newspapers every day where people complain of this, of that, where treaty rights are being abused. Rich people, educated people, how many of them have followed Shanique Myrie's example? The court is here, demonstrated its utility to give citizens their rights. Use it. Now, I must mention that that is not the only case, though, involving freedom of movement, because we have another case which has been fully articulated before us, where another citizen of Jamaica, has brought cases against the governments of Belize and the governments of Trinidad and Tobago because of perceived breach of his right of freedom of movement due to immigration laws which seem to restrict the entry of homosexuals into their countries. This is a matter which has been fully articulated, and the court is still considering its judgment. Now, I mention this because we have a very proud record of the court of acting quickly. We have performance standards which show that if you file a case before our court, you're going to get a judgment within 12 months. Once the case is heard, you're going to get your judgment within 3 months of the hearing. And we have been sticking to that. This case has been a bit of an exception. They've taken a bit longer to deliver the judgment. Because, you know, one of the guarantees in the original jurisdiction is that judges are not allowed to give dissenting opinions. We got to work together to fashion one decision of the court so the community is not affected by the views of individuals on the bench. You've got to get the collective wisdom of the court as a whole. And we think that's a very important guarantee of high quality decision making, which will work to the benefit of the community as a whole. Having said that, though, we will be delivering the judgment within the next month. Now let me come quickly to the appellate jurisdiction, because you're going to be faced with the decision. Before I go there, I must make the point. Whether you accept the appellate jurisdiction or not, you and Antigua have the right to access the original jurisdiction of the court. And the government is bound by it. You know, one of the interesting things about the original jurisdiction too, whenever we give a decision in the original jurisdiction, it binds every government, even if they were not a party to the case. So the decision in the Shanique Mary case binds the Antigua government. It's very important to realize the way in which integration has already been influencing and benefiting the region. Now, the Privy Council has been our final court of appeal in these regions for, I suppose, about 300 years, for as long as we were part of the colonial administration of the British Empire. But you know, the point I want to make to you on this, that after the Second World War, a war in which, I say, Caribbean men, not yet free and independent, stood shoulder to shoulder with their colonial masters to fight against the scourge of Nazism, which tried to establish a world order based on racism. Contributing, therefore, to an important development in human development. And I say that we were part of the forces which led to the establishment of the Universal Declaration of Human Rights, establishing that every man and woman on this world is equal, has equal rights, pride, and dignity with anybody else in the world. Principles which have led to the views that colonialism is an affront to human dignity and independence and equality. The British government has been part of the noble and laudable international movement to end colonialism. And have even participated in international conventions pledging for the removal of the last vestige of colonialism. And they have walked the walk by granting independence to our Caribbean nations. The first one as long ago as 1962, when Jamaica and Trinidad became independent. But at that time, the administration of justice in our countries did not have a court that could replace the Privy Council, so that the generosity of the British government allowed us to benefit from their welfare in the provision of a final appellate jurisdiction. And we have benefited from this. Trinidad and Tobago and Jamaica have been benefiting from this welfare for well over 50 years. Antigua has been doing it now since 1971. But are we content to be beneficiaries like that forever? The Caribbean governments took a stand and they established the Caribbean Court of Justice, one of whose objectives was to replace the Privy Council as the final appellate court of justice for our countries, to complete the circle of independence, making certain that we stood shoulder to shoulder with people around the world on a footing of equality. Now, the court is no longer speculation. It's been in existence for 10 years. And it has a track record which anybody can check. I think that the most important work that we have done can be seen in the high quality of the jurisprudence of our cases. Today, there's no time to review this for you, but a lot has been written about this, and in fact, over the next few months, I'm sure that there will be other opportunities to discuss this. But I just want to mention to you two small points. From Barbados, you had a very interesting case of Joseph and Boyce, where the CCJ delivered a legal principle which nowhere else in the world had this matter been addressed in that way before. And today, it's a principle which you see being applied in several other courts, including the Privy Council. Now, it's a case which you all might know about. It's a case of Boyce, Jones and Boyce from Barbados. And in a very simple way, these people had been convicted of murder. And after exhausting all of their appeals, they tried to go to the Inter-American Court of Justice. And the Inter-American Court of Justice was taking so long that the government of Barbados decided not to wait and to order the execution. And these people said, but look, Barbados is a part of the Inter-American Convention, which gives us a right of appeal to the Inter-American Court. You can't do that. And the government said, yes, it's true you signed the convention, but it has not been incorporated into the laws of Barbados by an act of parliament, which in fact was the strictly legal position. But the Caribbean Court of Justice said, if a government enters into a treaty arrangement for the benefit of its citizens, and it conducts a public information program which allows people to feel that they have enjoyed these benefits. And in that particular case, the government had facilitated and allowed those particular appellants to go before the court. The Caribbean Court of Justice said, this court will enforce the legitimate expectations of the citizens to benefit from rights of that nature. Landmark decision, which benefits the people of this region. Another interesting case, which I mentioned, is a case from Belize. And I mention it only because I've been hearing so much talk these days about what is being done to arrest corruption, to improve qualities of integrity in public life in our region. And again, the CCJ was part of a case which established a principle which had not been done anywhere else in the Caribbean before. All the since then I've heard that there are a number of cases which are applying the same principle. In Belize, you had a case where ministers of government were alleged to have misused their power to sell public lands in suspicious circumstances at grossly undervalued prices. And the court said, you don't have to rely on the criminal process. You can sue these people and make them pay back the money to the state. Now, another important issue that the court has dealt with. In Guyana, they inherited a legal regime called the Roman Dutch system, which was not developed to take account of many modern concepts in land law. And the court has given many landmark decisions modernizing the land law of Guyana. And the final point I'll mention on this point was that how often do international supervisory agencies identify that a court has delivered a judgment which has made the most impact on a particular subject worldwide? The CCJ has been the benefit of such an award in a decision dealing with the application of arbitration law. So I'm saying that we have had a proud record of high quality jurisprudence. I must end here because I notice I've run out of time. But I'd just like to say two other small things. That we think that having a final appeal court creates an opportunity for benefits to improving the quality of justice administration in the region. Because final appellate courts supervise judicial education, capacity building, they stimulate and supervise reform programs, and they assist in improving the quality of justice delivery. And the CCJ is ready and willing to undertake this activity within your community. In fact, we have already started doing that because the CCJ is the implementing agent for a project called the Jurist Program on behalf of the governments of Canada and the Conference of the Caribbean Chief Justices, which is aimed at improving the quality of justice administration within the country, within the region, and with special emphasis on improving the efficiency and expedition, and paying special emphasis on ensuring that the courts are responsive to the needs of women, men, children, and the poor. The project is already at work, and a number of projects have been commenced and are in progress. I'm beginning to enjoy talking to you. The master of ceremony has been very polite, but I notice I've exceeded my time by quite a few minutes. And I say thank you very much.
Thank you very much, Sir Dennis. You've opened our eyes once again in explaining the difference between the original jurisdiction and the appellate jurisdiction. My friends, I'm asking, the way has been led by some of our brothers and sisters in Sri Lanka, Australia, India, Hong Kong, Singapore, and close to us, Barbados, Guyana, Belize, and Dominica. Remember that statement. It is offensive to our sovereignty that a foreign tribunal should be our final court of appeal. That must be offensive to every Caribbean man and woman in all the region. And I'm asking the Antigua and Barbudans to bear that in mind. It is offensive to our sovereignty that a foreign tribunal should be the final court of appeal in our region. I now call on the National Youth Choir to present a special piece for us here. This is a choir that is very well trained, and always they do us proud in their presentation. And I would like to tell you too that from today there will be constant programs all over the country, all designed to inform, to enlighten, and to educate as to the reasons for the CCJ and its importance in the region.
Check. Okay. Shadowland, the leaves have fallen. This shadowed land, this was our home. The rivers dry, the ground has broken. So I must go. Now I must go. remember my pride. I have no choice. I'll find my way. Take this breath. One lies out there. And where the journey may lead you, let this breath be your guide. Though it may take you so far away, always remember your pride. And where the journey may lead me, let this breath be my guide. Though it may take me so far away, I remember my pride. He's unviable. He's unviable. I will return. Oh, Bessibo. He's unviable. I will return. He's unviable. He's unviable. Bessibo. Bessibo.
Oh, what a beautiful rendition. The words of Shakespeare. If music be the food of love, play on, sing on. Wonderful rendition. This sets the stage for what we intend to do in a few short months. Once again, thank you very much. Well done. In the meantime, I wish to welcome retired Justice of the Caribbean Court of Justice, Ms. Desiree Bernard from Guyana, former Chancellor of Guyana. She's here with us. Thank you very much. She'll be taking part in the discussions tomorrow and will help to clarify certain questions which the members of the public will ask in this matter. Now it gives me very great pleasure personally to introduce the next presenter, the Honorable Baldwin Spencer, the leader of Her Majesty's Opposition for St. John's, Rural West. This man, a trade unionist, a friend of mine for many years, fought many battles he and I have fought, in labor and otherwise. Great man. Here he is this morning, my friend, the Honorable Baldwin Spencer. Please greet him.
Thank you very much, Mr. Master of Ceremonies. May I, in the interest of time and brevity, accept the protocols that have already been observed, and to say how delighted I am to be participating in what I consider to be a historic and very important engagement with the people of Antigua and Barbuda, the launch of the public education and consultation leading to the referendum for us to finally decide that we will no longer continue to tarry or to loiter at the doorsteps of colonialism and imperialism. And the issue that we have to address as a people is whether or not this is an issue that is partisan politically. And I have been asked to speak briefly to that. My very presence here is indicative of the fact that this ought not to be approached on a partisan basis. This has nothing to do with political parties and their positions, because I can tell you that there are very strong views right across the political divide, one way or the other, on this issue of the CCJ. So that much has to be accepted. What is going to be critical in our approach to educating and consulting with the people of Antigua and Barbuda, it must not be seen as a partisan exercise. And we have a responsibility as leaders to be able to say to the people of Antigua and Barbuda that, look, this is a matter that requires us as a people to be able to make a fundamental decision which has to do with us as a people, not only in Antigua and Barbuda, but throughout the Caribbean. When we talk about Caribbean civilization, when we talk about moving from a position where colonialism and imperialism controlled our decision-making processes to a position where we are not only a free people, but we have to make sure that we form a society in which our decision-making processes are ours. That is what a true society is all about. You're being able to make decisions for yourselves. And this is clearly not a partisan issue. I have to tell you personally, since I'm here, Mr. Master of Ceremonies, I know we are pressed for time, but I have to tell you, for me personally, I've gone through a process of evolution, if you like, in terms of the CCJ. From a position where I felt, oh, clearly, we are not ready. This is not going to work. To a position, yes, we are ready, but there are issues that we have to address. To a position now where I am totally and completely convinced that we must move to the final stage of acceptance and implementation and decision-making, because we are already part of the CCJ. We have adopted this original jurisdiction, and all we want to say, listen, we have now arrived at a position, as a matter of fact, as far as I'm concerned now, for Antigua and Barbuda, we must not be seen to be lagging behind in important decision-making processes. Antigua and Barbuda has always been a leader when you look at the Caribbean situation and decisions. So we've got to get there and to deal with it. What I wish to say to all of us, and I'm speaking now directly to the people of Antigua and Barbuda, right across the political and social divide, we have got to, as leaders, make every effort to raise the consciousness and the understanding of the people of Antigua and Barbuda as we move forward with this process, because there are fundamental misgivings. We cannot ignore that. It is our responsibility now to use this mechanism and this opportunity of embarking upon this process of education, sensitization, consultation, dialogue with the people, and let us all understand how important it is for us to move and to be able to say that Antigua and Barbuda has removed the last vestige of colonialism and, I might add, imperialism from the psyche of the people of Antigua and Barbuda, and by extension, the Caribbean. So therefore, let the process of education, consultation, and sensitization begin in earnest. Thank you very much.
Thank you so very kindly, my friend. This is the beginning of great days ahead. You can remember the Mighty Swallows sang a song some years ago, The Dawn of a New Day. And the name slips me now, but I think it's King Franco, sang a song, Yes, we are ready. Ready to take a stand, ready to redeem our native land. With body, mind, and soul. That's correct. Thank you very much, Mr. Spencer. You have demonstrated today that you are a true national, concerned with the development of this country, of Antigua and Barbuda. The pleasure is mine now to introduce the final speaker for this morning's session, before we take a break. A young gentleman who has led this country with some foresight. Vision, determined to carry on the dreams of our forefathers, that of the great Surveyor Cornwall Bird. Regional integration, always be in the vanguard, moving forward with one purpose, to unite this country and also to lead the sub-region in matters of importance. Remember, Belize, Barbados, Guyana, and Dominica are the only countries thus far that subscribe to the appellate jurisdiction. Let us therefore take our stand. Let us demonstrate our leadership. Let us continue what was started by the great Surveyor Cornwall Bird. And let us put our hands together to welcome the Honorable Prime Minister of Antigua and Barbuda, Gaston Brown.
Thank you, Mr. Master of Ceremony. Your Excellency, Sir Rodney Williams, Governor General of Antigua and Barbuda, President of the Senate, the Honorable Alincia Williams Grant, Speaker of the House of Representatives, Sir Gerald Watt, President of the Caribbean Court of Justice, Sir Dennis Byron, colleague ministers include Sir Robin Yearwood, Sir David Simmons, members of the Diplomatic Corps, permanent secretaries, distinguished ladies and gentlemen, and most importantly, the Honorable Leader of the Opposition, Mr. Baldwin Spencer. I'm absolutely delighted to once again share a very important platform with the Honorable Leader of the Opposition. And perhaps we would not have been here today had he not decided to cooperate with my government and to pursue this initiative in a constructive and bipartisan way. And I thank him very much for his participation today. In fact, I'll go as far as saying that he is normally at his best whenever he cooperates with my government. Ladies and gentlemen, I welcome you all to this very important ceremony marking the launch of the public education campaign for the adoption of the Caribbean Court of Justice, the CCJ, as our final appellate court. It is with great pleasure and pride that I address you as we seek to share insights, knowledge, and information with the entire voting population and our youth about the Caribbean Court of Justice and the choice we will face in a few months to make it our final appellate court. It was merely a couple of weeks in office when on July 1st of 2014, during the CARICOM Heads of Government Conference at the Grand Sandals Resort, that I signaled my government's intent to have the CCJ as our final appellate court. During my presentation, I said, and I quote, "We can never be truly independent in the region while our final appellate court is a court of our former colonial master." I also indicated that Antigua and Barbuda will not loiter on the matter, that we will demonstrate confidence in our own by taking the appropriate steps to join the appellate jurisdiction of the Caribbean Court of Justice as soon as practicable. It is widely accepted that all citizens and residents of our beautiful Twin Island state could rely on my government for the integrity of its words and the reliability of its actions. True to form, and as promised, today we embark on the path to make the CCJ our final appellate court. Whereas our government enjoys in excess of a 2/3 majority in the Parliament and is assured of the passage of the necessary legislation to give effect to the operationalization of the CCJ, our Constitution mandates that we obtain the fiat of the people by way of referendum. Evidently, the men and women who journeyed to Lancaster House in 1980 to negotiate a new constitution for our country deemed it important to provide the people of Antigua and Barbuda with a voice whenever our constitution is to be altered. Any provision of the Constitution that is entrenched requires the vote of the people. In other words, a referendum is required to change certain constitutional provisions, including the proposed change to the Caribbean Court of Justice. Adoption of the Caribbean Court of Justice is just one of several bold moves that my government has opted to empower our people, and this will complete the cycle of sovereignty of our state. We have adopted many other initiatives, but it's certainly one of the most important initiatives we have adopted. As I said before at Sandals Grand, we can never be truly independent in the region while our final appellate court is a court of our former colonial master. There are many benefits for the citizenry of Antigua and Barbuda to become a member of the CCJ in its appellate jurisdiction, several of which I will outline during my presentation. It is quintessential that we support this progressive change. I therefore make a clarion call for all registered voters in Antigua and Barbuda to support this important institution of regional governance and sovereignty. The Privy Council is clearly an outmoded colonial construct that was designed exclusively for the wealthy for the wealthy few and has failed to provide broad-based accessibility and dispensation of justice to the masses. Acceptance of the CCJ will not only complete the cycle of sovereignty of our state, but it will safeguard and ensure the swift and accessible justice for our citizens. Justice is not only delayed because of the remoteness of the Privy Council, but in many instances was denied because of the inaccessibility associated with the prohibitively high cost. Even today, justice is being denied to the majority of our people who find it cost prohibitive to take their case to the Judicial Committee of the Privy Council. Having the CCJ as an all-inclusive appellate court will cure this egregious injustice of exclusive justice for the few that has plagued us since 1833. The CCJ is an all-inclusive and innovative court with some of the most experienced and qualified judges emanating from the Commonwealth of Nations. The CCJ judges are ranked among the best to be found anywhere in the world. In addition, the independence of the court, with its innovative self-funding mechanism, has insulated the court from political interference. This is a feature, a safeguard that distinguishes it from other courts. As a consequence, its decisions during its 10 years of operations have been widely accepted and respected. In many instances, the judges on judgments emanating from the court have been utilized in other final courts globally as benchmarks and precedents. The fairness of the decisions of the CCJ to date could only bolster our confidence in the quality of the jurisprudence that emanates from the court. As stakeholders, as owners of the CCJ, we should all be proud of its work and should spare no effort to support and fully embrace the court. Sir Shudit Ramphal, a distinguished son of the region, in a paper entitled Creating a Regional Jurisprudence, spoke emphatically about the quality of the CCJ judges and equated them to those of the Privy Council. He stated, and I quote, "Surely it is an act of egregious contrariety that we have withheld so substantially its appellate jurisdiction in favor of the Privy Council. Do I need to remind you that from the Caribbean shores, we have sent judges to the International Court of Justice, to the Presidency of the United Nations Tribunal on the Law of the Sea, to the International Criminal Court, among others?" End of quote. Many of these judges from the region, who rank among the best in the world, have sat and can sit on the Privy Council. Why then are there still so many among us who believe that we cannot get fair and uncompromised justice from the same judges that the Privy Council and other international courts have celebrated and have held in high esteem? I ask the question rhetorically, why? Is this a lack of confidence or a form of self-hatred for our own? Perhaps these individuals are unconsciously bounded to the past and have not liberated their minds from the psychological shackles associated with institutions of colonialism and slavery. Our country is being called upon today to decide whether in this 35th year of our independence from slavery, from independence and previously slavery, from independence from Britain, whether or not we should continue to loiter on the doorsteps of its institutions or assert our dignity and self-worth in choosing our own. That is essentially the question that is before our nation. Again, I repeat, if after 35 years of independence, having survived colonialism and slavery, if we will continue to loiter at the doorsteps of the Privy Council. It is a question encapsulated in the immortal words of the late Robert Nesta Marley, as he urged our people, as he urged every one of us, and I quote, to emancipate yourselves from mental slavery. None but ourselves can free our minds. End of quote. It is a question in which all of us have a very big stake with future generational consequences. Do you want our offsprings to be ashamed of our failure to act, to support our own, to embrace our own? Do you want our future offsprings to endure the indignity of begging accommodation at the Privy Council? Our forebears would expect greater resilience and confidence in our own, in keeping with that rich legacy of independence for which blood, sweat, and tears were shed for empowerment. Our forebears were staunch integrationists who developed and supported regional institutions for the benefit of the region's people. It was our late father of the nation, Sir Vere Cornwall Byrd Sr., Forbes Burnham of Guyana, and Sir Errol Barrow of Barbados, who formed CARIFTA, the forerunner institution of CARICOM, right here at Dickinson Bay in 1965. It is instructive that two of the pioneering countries are full members of the Caribbean Court of Justice, but Antigua is only a member in its original jurisdiction. Today, I say to you that we must continue in the tradition of our forebears by developing, supporting, and embracing our own institutions. Why should we beg accommodation in the court of our colonial master when we own our own CCJ, which is an internationally respected final court? It is not to say that we do not have an option. We have a most viable option in the CCJ that we have failed to embrace. It should be noted that the decision to stay with the Privy Council is not ours alone. At any time, the United Kingdom government can indicate that they will not hear cases from the Commonwealth to include Antigua and Barbuda. It was Lord Phillips, as head of the UK Supreme Court and head of the Privy Council, who complained that cases from the Commonwealth, including Antigua and Barbuda, was taking up a disproportionate amount of time of their judges, and that he was searching for ways to reduce the time spent on those cases. The intent, even though clothed in diplomacy, could not be any clearer. Evidently, the time spent on Commonwealth cases was impacting negatively on their own dispensation of justice to their citizenry, and they were prepared to compromise the time spent dispensing justice on our behalf. Now, clearly, if they continue to pursue that policy to reduce the time spent on our cases, then it will compromise the quality of the decisions in the future. So, with this intent, Caribbean nations may not only have to contend with the inaccessibility of justice to the masses, but may be faced with perverted decisions as less time is spent on hearing cases from the region. I believe that as a prideful nation, we ought to leave voluntarily and embrace our own final court instead of suffering the indignity and humiliation of being asked to leave sometime in the near future. Or do we want to kick this potentiality down the road for our offsprings to be faced with this humiliation and indignity of being kicked out of the Privy Council? Ladies and gentlemen, the CCJ, with full support of members, the member states in its appellate jurisdiction, will ultimately provide more opportunities for people of the region, especially the brightest lawyers among us, as they build their expertise to serve at the level of the CCJ. However, I must point out that judges who will sit on the bench of the CCJ may be chosen from any Commonwealth country. And presently, we have judges from other Commonwealth countries outside of the Caribbean who are serving on the benches of the CCJ. So the court has a very wide pool of judges from which to choose. The court is also an itinerant court moving from one jurisdiction to another to hear appeals. The cost of getting to the CCJ is therefore considerably less than the current choice that appellants now face. The CCJ is affordable. It was said earlier, 5 times less than the cost of the Privy Council. So if ordinarily it will cost you $50,000 to go to the Privy Council, then clearly to go to the CCJ, it will be 5 times less. Or if ordinarily it will take you $5,000 to go to the CCJ, it will take you $25,000 to go to the Privy Council. The math is very simple. The decision is very obvious, that having the Privy Council as our final appellate court is cost prohibitive. So clearly, by adopting the CCJ, justice will therefore be less costly and more accessible, certainly more accessible to the masses. Antigua and Barbuda is one of the contributors to the US $100 million trust fund. That self-funding mechanism that was put in place to ensure that the court is not subject to political interference, to ensure the independence of the court. Hence, there will be no additional cost to access the court in its appellate jurisdiction. It will cost us nothing because we have paid for it already. And as the President has indicated, we have even made additional investments in the CCJ based on our commitment to that organization. It is evident that it is in the best interests of our nation to maximize the use of all the services of the court, including the routine equipping and training of officials in the lower courts. In fact, the CCJ has one of the best technological platforms of any court or any court in the world. So clearly, by adopting the CCJ, that technological platform could be replicated right through the region, through all the courts within the community. I turn now to the point of improving the quality of life of our people. And as was said before, the quality of the life of our people is not exclusively about economics. It's also about the social aspects. And it also includes the dispensation of justice to the masses. Improvement of the quality of life for all who live and work in Antigua and Barbuda is a principal concern of my administration. We're approaching the development of this country in a holistic way. Not only has your government begun work to bring greater economic growth and thousands of jobs to our people, my colleague parliamentarians and cabinet colleagues are equally focused on justice for all, a very important aspect of our development. Justice is always paramount in all we do. It is one of the pillars of our development. The greatness of our Caribbean civilization is to be determined by the ultimate achievement of a people who have transformed an unjust society built on oppression and forced labor into a marvelous model of freedom, justice, and equality of opportunity. The end product, my fellow citizens and our esteemed friends, is full sovereignty, completing that circle of sovereignty with the attendant national and regional pride. We must continue to give each citizen in our developing island state more reasons to feel proud as we press forward to becoming an economic powerhouse in the Caribbean. Adoption of the Caribbean Court of Justice as a final appellate court for the Caribbean and Antigua and Barbuda will be seen as an advancement in our Caribbean civilization and another achievement to celebrate. On the topic of generational leadership, generations of leaders have delivered for the people of Antigua and Barbuda. The 39ers were the greatest generation ever. As I said before, they invented Carifta in 1965, when Barbados, Guyana, and Antigua and Barbuda began the second regional integration movement. I reiterate, since Guyana and Barbados have led in the movement to adopt the CCJ, Antigua and Barbuda is compelled, is duty-bound to join that circle once again. After the 39ers devolved leadership onto the 76ers, the OECS became the brainchild of yet another Antiguan and Barbudan leader, the Honorable Sir Lester Bryant Byrd. Antigua and Barbuda has been and must remain at the forefront of regional integration. Now, the leaders in these opening years of the 21st century are charged with the responsibility to transform and modernize our society and state for the benefit of all citizens and residents. That is why this upcoming referendum is the most important collaborative decision that government and opposition will jointly undertake. My colleague parliamentarians see this great leap forward as another in the significant historical movements to enhance the rights of citizens and residents. I ask you to pay attention to the upcoming public educational campaign and to join in making Antigua and Barbuda a leader in the OECS and the Caribbean. I now focus on the educational campaign. I have my own opinion, and I have made my position abundantly clear on the subject. I firmly support joining the CCJ. I hope that our people will follow the lead of their parliamentary leaders and vote yes at the upcoming referendum. It is an imperative that we complete this circle of independence and preside exclusively over our own destiny. What is envisioned for this public educational campaign is to provide the Antiguan and Barbudan audience with the benefit of the full spectrum of issues to consider. Because we want our citizens and residents to make informed decisions, not to make decisions based on misinformation. We want our people to equip themselves with the facts, to understand the risks associated by having the Privy Council remaining as the final court of this country. It is a decision that I ask you to carefully consider, as I believe that the choice which we make is sure to be consequential, and certainly if we make the wrong choice. It is a choice that we all and our children will have to endure for a very long time. Hence the importance of making the right choice. Our decision could prove pivotal to the jurisprudential history of the Caribbean. With this in mind, I have charged my esteemed colleague, Dr. Clarence Henry, the chairman of the National Coordinating Committee, to ensure that our people are fully informed and that the views of the people from the length and breadth of the country is taken into consideration, or the views are taken into consideration. I have asked that the committee, including representatives from religious groups, the media, the Bar Association, representatives from businesses, labor unions, and the opposition party, among other groups, are taken into consideration. The views must be reflective of a wide cross-section of the population. I've also asked for the youth to be included. Very important that we include the youth in the process. They represent the majority of our country's population. And it is important we engage them as much as possible, because they will be the inheritors of our choices. And they also exercise influence over their parents when there's a need. The committee will also be working with the Attorney General, the Honorable Stedroy Q.D. Benjamin, and the Antigua and Barbuda Electoral Commission to ensure that the referendum is fair and accurately represents the will of the people. At the end of the day, it is your decision, and we want to make sure that a referendum accurately reflects your wishes. I must point out that this is a non-partisan approach, which is the hallmark of the political maturity in this country. In fact, the leader of the opposition and I have shared the platform on several occasions on different issues. As my government continues to demonstrate maturity and participatory governance. We want to hear all views. We want to make sure that every Antiguan and Barbudan has the capacity to participate in the decision-making processes. This initiative has the strong support of the opposition party. You just heard from the Honorable Leader of the Opposition. It has the full support of the United Progressive Party. While it is clear that we will not agree on many things, in July of last year, we were able to have a meeting of the minds. In fact, I took the initiative to call on the President of the Caribbean Court of Justice at the time to intervene and to assist in soliciting the support of the members of the opposition. And today, I would like to thank him for making that a reality. The participation of the members of the UPP demonstrates a great deal of political maturity, and more importantly, demonstrated that our paramount interest is ensuring that the people of this great nation are well served. We must always put the people first, to have them at the epicenter of our development. Representatives of the government and opposition signed a memorandum of understanding which states that we will work together to inform the people of Antigua and Barbuda about the choice that they've been asked to make. We both pledged to leave our political differences behind and to enter into this project with a spirit of cooperation and goodwill. I have not wavered from that conviction, and I believe that my colleagues in the UPP are equally steadfast. And I also want to acknowledge the presence of the political leader of the UPP, the Honorable Harold Lovell. The public education campaign and the resulting referendum will benefit from a bipartisan approach. And that is critical because the benchmark, the threshold is extremely high. What is required is a 2/3 majority. 2/3 of the voting population of this country must say yes, must vote yes in order to make this a reality. So if we were to approach this issue on a partisan basis, it would have been doomed to failure. And that is why we said that if at any point this very important national development issue disintegrates into partisan politics, then we will have to leave that decision for another day. This is a very important developmental issue. It has nothing to do with partisan politics. The members of the UPP, the leadership of the UPP, they have so demonstrated that this is not a partisan political issue. It means, therefore, that the biggest threat facing this referendum, this national referendum, is ignorance. And that is why we must embark on this public education program to hit every home, every street, every community in this country to make sure that we share the facts, to allay the fears of those who are not aware of the benefits of having the CCJ as our final appellate court. My friends, I say to you this morning that we are in this together. All of us as Antiguans and Barbudans, irrespective of your color, creed, class, faith, irrespective of your political persuasion or sexual persuasion, we are all in this thing together. We must all pull together to ensure the success of this referendum. And as we say from time to time, failure is not an option. And I expect our people to treat with this issue responsibly. In fact, each Antiguan and Barbudan has a responsibility to equip himself or herself with the facts before he goes to vote. No one should vote in this referendum out of ignorance. In fact, before you vote out of ignorance, you're better off not exercising your franchise because you'll be doing the country a disservice. I must take this opportunity to thank the Governor General of Antigua and Barbuda, Sir Rodney Williams, who hosted that bipartisan conference with the President of the CCJ as the facilitator. I thank you, sir, for your participation, the role you played in bringing the two teams together. I have been unapologetic in my desire and indeed my unswerving commitment to make Antigua and Barbuda an economic powerhouse. And as I've said to the nation time and time again, this is not a cliche. It is a vision in which I expect each Antiguan and Barbudan to buy into, to adopt, and to work assiduously to achieve. I've said that my government may not necessarily achieve that vision, but at some point in the near future, even in retirement, even after I would have passed, I expect this vision to be achieved. If not by the Antigua and Barbuda Labour Party, perhaps by the United Progressive Party or some other party in the future. But this vision of making Antigua and Barbuda an economic powerhouse must be achieved. And it requires all hands on deck. And understand too that in order to become an economic powerhouse, that we must preside over our own jurisprudence. We cannot be begging lodging in another country's court and boast that you're an economic powerhouse, no matter how successful you may have been economically or socially. That cycle, that circle of independence cannot be achieved until such time as we are responsible for our own jurisprudence. I believe this referendum will show our nation and those among us that the interests of the people is more important than political jousting. That we must continue to work together. In fact, that alone is reason to be proud. The fact that we are working together, that the leaders of this country, notwithstanding their political persuasions, that they are working together. Now, ultimately, the decision is yours. The people of my beloved Antigua and Barbuda. It will be your decision. You will decide the fate of our Caribbean Court of Justice. You will decide on whether justice should remain the domain of the haves, or whether we use this opportunity to break down that barrier to facilitate the dispensation of justice to all. Ladies and gentlemen, it has been approximately 20 months since I placed on record my government's vision to see Antigua and Barbuda have the Caribbean Court of Justice as its court of final appeal. And here we are today, at the cusp of the fulfillment of that vision. It goes back to my essential mission to ensure that the people of Antigua and Barbuda will be able to look to their government their nation, and their institutions with unrestrained pride. For this, we must begin to embrace our own with pride and dignity. We cannot have economic development and the empowerment of our people without strong institutions that engender growth. I therefore seek your support for this referendum. We should approach this referendum with confidence, knowing that our decision will serve the best interest of future generations. Let us remember that we have in the CCJ a court that is free from political interference. Let us remember that we have in the CCJ a court made up of the most brilliant minds whose mettle has been tried and tested in international courts. It is not a theoretical construct. The CCJ is real. It is functioning. The decisions are there for all to see. There needs to be no fear, because the court in 10 years would have proven its worth. Let us remember that we have in the CCJ a court whose judgments have been admired and cited internationally. Let us remember that we have in the CCJ a court comprised of our own, people of our culture and our region, people of our own experience. Who better to dispense of justice in this region? Let us not dither on this issue. I implore you to fully embrace our own court, the CCJ. Let us support the proposed change to the Caribbean Court of Justice as our final appellate court. I thank you in anticipation for your yes vote. And I believe that we have it. In this, our 35th year of independence, let us close the circle. Let us emancipate ourselves. Let us embrace the CCJ. Let us work collectively to ensure that we have a successful referendum. May God continue to bless our beautiful Twin Islands state. I thank you.
Thank you very kindly, Mr. Prime Minister. Remember, it is offensive to our sovereignty that a foreign tribunal acts as our final court of appeal. At this time, we will take a short break for 15 minutes for refreshments. When we return, we shall hear from, among other people, we shall hear from Harold Lovell, Sir Dennis Barron once again, Justin Simon QC, Sir David Simmons, and Sir Gerald Watt.